Good evening. How are you? Well, it's been a long day for me. I was in D.C. today and was arguing before the U.S. Court of Appeals for the D.C. Circuit. Some say it's the second most important court in the land, but I'm still partial to the Second Circuit, which is in New York. And given who's on the Supreme Court these days, I don't think there's any comparison between New York and the Supreme Court. But there it is. The Jefferson report goes like this. It's about 56 degrees. The wind is at a half mile an hour, I'd say. The sun is still shining, but dimming. And that's in part because they couldn't get around to getting here until now. The fun thing at our place is we took on a couple of banded cows, and if I have a picture of it, I'll share it. And but the news continues to be both good and what we expected, but what we expected is in the bad category. So, for example, Pecker is still on the stand, or was on the stand. I don't know if they finished completely. And Pecker was basically talking about McDougal, who was described as a Playboy model. Is that what they were? They were models. I never understood that. There were guys in my class in high school who had the Playboy magazine, and they were always saying that they were reading it for the jazz. The jazz is really, really good stuff. It's pretty funny. So it appears that Pecker talks about how Trump thought she was a nice girl. And Pecker believed that he was having an affair, all of which fits the notion that that was an inconvenient truth for the campaign he was having. And the defense did get a chance to start talking to Pecker today. And they did something very interesting, because there's supposedly a meeting at which Hope Hicks is at, in which they're discussing some of this material with Pecker. And the cross-examination involved asking Pecker if something didn't refresh his recollection, suggesting the meeting wasn't as he said it. But the judge criticized the defense attorney out of the presence of the jury, because it appeared that document did not have the reference, nor did the witness need to be reminded of something, which these are forms we go through, the katas of trial work, for how you bring a case to a jury and they're allowed to hear it. So the judge is going to look into that. What it is here's how it would work. Isn't it a fact that the meeting didn't occur as you said? No, it occurred the way I said it. Well, right here I have a memo. Isn't it a fact you need this to refresh your recollection that the meeting was such and such? When that document has nothing, but it's a gimmick, an unethical one for the jury. Now, the judge didn't say that's what happened, but that's what the judge's questions were for the defense. So that continues. That's good. It continues to diminish Trump. That's good. Particularly when you consider what the Supreme Court was doing. The Supreme Court cult of six was trying to find a way, in my opinion, to delay the case. Now, some are surprised by that. But because we have the cult of six, and because they are so political, and they are so unpatriotic and unfaithful to their oath of office and to the nation that has done them so well, that they would think to save this scoundrel, even as he's on trial for doing the very thing that Trump is seeking immunity from. So the way they're talking about the case and before the Supreme Court, to unfairly summarize the word games they played all day, was there are private acts and there are public acts. And they may want to draw some lines, and they may not do that until June, or who knows, maybe later. And they may suggest to go back to the trial court, to Judge Chutkan, and then Judge Chutkan could look at it and decide to try the case on, quote, private acts. So all of this is gibberish to get past the deadlines, so that I guess Trump has a chance to become president and try to find out if he can pardon people right and left from his corrupt bargain with all the various people in and out of government that have brought him to where he is today. Now, somewhat off the topic is the fact that Harvey Weinstein's 2020 conviction, getting him 20 years, 22 years, got him a hefty sentence. Well, it was overturned today by a very fine attorney. I haven't heard his name in a long time, Lou Idella, Aidala. And I watched him in court when I was in New York. I'd see him a fair amount. And he was a tough lawyer. He was a very good lawyer. So he said he got the case thrown out for all the defendants in New York State. But here's the point of it. People are upset that it was thrown out because of what Harvey Weinstein was principally charged with. And so he's charged for a crime, but under a doctrine referred to variously as prior bad acts or similar acts, you're allowed to introduce information, evidence that has not been charged in an indictment that relates to perhaps a defendant's state of mind. I would never do such and such. Somebody takes a stand and say, well, he did it with me. And so that's how it would get in. Now, you're supposed to weigh the possibility of some prior offense that for whatever reason you can't or don't charge with the prejudice that it brings. So, is it remote in time? Is it really similar? Is the manner in which the prior offense or bad act was committed so similar to the present one as to suggest a specific and unique pattern? And so you can use it to show knowledge, intent, and things like that. But increasingly what I see is that prosecutors find these other acts and use them as a make-weight to compensate for a lightweight case. Now, I don't know how strong or weak this case was. I didn't follow it. I do know that it was a tough case. All these cases are tough. And it's often you said, he said kind of thing, she said kind of thing. So, but that aside, now all the people are complaining that these victims came forward as similar acts, and do they have to go through this again? And my answer in part is, depending on which ones seemed disconnected with the actual charged misconduct, those people shouldn't appear again. Otherwise, why wouldn't you get the same result? So, I haven't read the opinion, but it's left to two decisions. One is, should Bragg bring it again? I don't know enough to say what he should or shouldn't do. But my advice would be, you better get better or different or lose these other prior acts, or you'll be in the same trick bag. Now, the decision was not overwhelming. It was, if I'm right, 4-3, 5-4. I think it was 4-3. I think that's the right number. And the significance is that there was a strong dissent, but that's not the decision of the court. Now, in fact, the appeal that I was working on today involved a charge about a prior similar act that I contended shouldn't be in the case. So this is not surprising law. And it's not necessarily misconduct by the prosecutor, but you really have to be careful with this. I had a case in Ohio that I got thrown out because of prior similar acts, and I've had a good experience elsewhere, and I'm hoping that the court will see their way in this case that I handled today in the D.C. Circuit Court. And it's a case that's before Judge Chutkan. And, don't get me wrong. People make mistakes. The people who bear the burden, however, are the defendants in the case. And I'm not crying crocodile tears for Harvey Weinstein, but I am saying that we waste a lot of time and put people through a lot if we don't think carefully about the evidence we put in and whether or not it is unfair and prejudicial. Hard but fair shots, that's what you take in a case, that's what you do in politics, that's maybe what you do in life. Now, Harvey will not be out of custody. He will stay in custody until the decision is made on this trial. He's been convicted in LA, and I think he has a 16-year sentence there. So he's not walking out the door anywhere. So you can be angry, but there is good and strong law out there, and prosecutors, I think, are going to have to be more careful about what, quote, prior bad or similar acts they use. So I don't tell you this to be aggravating. I tell you this because it's not quite so simple. If you're going to charge somebody with a crime and prove it, fine. And when I was a puppy lawyer, there was more of that. But this is turned into a way. Every case now has a hearing on whether or not some prior act will be admitted or not, and including the one that's going on with Trump right now. So you have to be careful about those things. I enjoyed being in D.C. today. I stayed at a hotel a couple of blocks from the courthouse because it's my presentation was at 9:30, and I didn't want traffic to mess it up. But I walked by some homeless, including Snyder's whole group, which was a homeless advocacy group, and had to walk past people who were literally sleeping up against stone walls near the courthouse. And there's no reason why a society that can splash around billions of dollars can't figure out a way at least to give shelter in the night with all the public buildings we have and all the possible ways we can deal with it. And we should. If we're true to the notion that our standard of civilization means that we care about the Commonwealth, all the people. But we're not as good as we say, and we don't work as hard as we should. And we're in this mess because enough people didn't stand up and fight. But the New York justice system is going to bring this bastard to the bar and put him in jail with any luck. And we're going to win this election because the people will not stand for this in the end. And we're perhaps going to take the Senate and the House. And don't vote for any Republican, even for dog catcher. Not until the party resumes having both civil discourse, but also respectful of equal rights among men and women, that equal justice before the law, non-discrimination, and a government that's democratic, not monarchical, and then doesn't have a pig like Trump at its head. So, that's what I got to say here in the Cathedral of Trees, and I look forward to talking to you tomorrow. Bye-bye.